Dr. Miller-Meeks, you're recognized for 5 minutes.
Thank you, Mr. Chair, and I thank all the witnesses for being here, and I also thank the Chair for having this hearing. I will just say, given the last question, I'm more interested in a pay raise for the American people than I am for a pay raise for those who are within the federal government. And let me also say that I think it's appropriate to point out that, as the ranking member said, Congress's job is to make the laws, and therefore this requires Congress to actually do its job, which I think all of you said. And I will give you an example of why this decision is important. So Congress passed a No Surprises Act bill, and it was to address an issue with patients getting surprise bills when they thought that they were in network and insurance companies decided they were out of network, or an expert being called in who was on a panel of doctors in a network, but then decided for reimbursement purposes was not on a panel. Congress was very explicit in how it wrote that legislation. However, HHS, under this administration, decided to interpret in a different way. The Loper decision forces us to craft laws in consideration of what happened in the Supreme Court in the Loper decision, and to do a better job, as we did with the No Surprises Act, but an agency had interpreted it in a manner that they wished to, and against the intent of Congress. So that's why I think this is important, and I know that's my opinion of that, but why I think the Loper decision is very important for Congress. Mr. Gaffney, post-Loper, how will the courts review potential challenges to VA regulatory actions not based on formal rulemaking, such as internal guidance or directives?
Thank you for that question. So post-Loper, instead of looking at whether VA's regulation is a reasonable interpretation of an ambiguous statute, courts are going to instead use their ordinary tools of construction to decide the meaning of that statute. And that could take several forms. One of the things they could do is look to see how the agency has interpreted and applied that statute over time. And that agency practice can be a factor that the courts will look to, but it won't be the exclusive factor that courts look to. They'll continue to exercise independent judgment.
And can Congress strike a balance between leveraging potential VA expertise, i.e. doing that prior to making legislation, while maintaining strict legislative oversight and accountability, and putting forth what they intend legislation to be?
There certainly seem to be tools for Congress to do that, yes.
Thank you. Dr. Wallach, what recourse is there for this committee if the VA does not issue a formal rule, but instead issues guidance or directives that the committee disagrees with?
I think my view is that Congress just needs to pass more laws. It needs to be able to pass little laws that say you've interpreted wrong and we need to correct you. And that needs to be a fairly efficient process. That is the ultimate tool. So if you have that threat of doing that, then maybe when you engage in informal communications as oversights, they're more likely to just listen to you in the first place.
Under Title 38 United States Code Section 1714, Congress clearly stated that prosthetics for amputee veterans are intended to restore health and quality of life. However, in 2021, the VA issued a rule requiring that access to adaptive prosthetics must be directly tied to an active medical treatment or rehabilitation program, and they determined medical necessity, not the doctor. We believe this rule differs from Congress's clear intent to ensure lifelong access to prosthetics for veterans to restore health and quality of life. What recourse does Congress have in this circumstance?
Again, to me, it seems like, well, they got it wrong. Go in and tell them to get it right. I don't think that anything about, writing statutes is impossible. It's an inexact art, to be sure, but when you find out that it's gone a different way than what you wanted, you just have to go back in and fix it. And I know it's very difficult to move legislation through Congress these days, but we have to think about ways of making it easier when there is a situation where, especially on a bipartisan basis, members of Congress say this is just not what we intended.
Or someone has to have enough means to pursue a lawsuit, which is tremendously unfortunate and works against most of our veterans. Mr. Vecchione, Congress stated that the VA must consider all of the evidence when deciding a veteran's claim for disability compensation. Do you think VA's regulation requiring an automatic denial of a veteran's claim if the veteran misses their disability compensation exam fulfills Congress's intent?
No, I don't. It's like the Buffington case where Congress didn't put in a statute of limitations. Our client put in for his benefits because he'd been put back on active duty, and then he was denied his benefits. Congress hadn't done that. It sounds like the same case.
Thank you so much.